Yo, 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 what's good with y'all beautiful people? Such a beautiful day out here today, man. Just thank everybody for everything that has taken place. To this beautiful day. A lot of you guys out there are going to be celebrating the 4th of July. So happy 4th to you guys and what they consider the Independence Day of the United States of America. And there's going to be a lot of people out here that's going to be celebrating today and have no idea about their rights. But just glad to have an off day, fire up the grill, be around family, pop some fireworks, disturb all the veterans who have been at war, that type of thing, right? Absolutely. Absolutely. Welcome to In God We Trust Academy, everyone. And we give thanks as always for your guys and your participation and everything that you do to make this possible as well. We give thanks to the Almighty just for everything that has transpired up until this very moment right now. All righty. Got a few special things that we're going to do with you guys today. Kind of missed getting on here with you guys last night, but kind of had a few other things I needed to do and get done. But however, I was up to about, I don't know, I was up quite a while. I don't even remember looking at the time before I laid down. I just know it was pretty late. But other than that, though, man, it's beautiful. So we got something for you guys, though, today. All right. So as you guys know, we got a few upcoming classes here. Trust Administration class, July the 26th. So let me get these announcements out the way for you guys. July 26th. Trust Administration. Okay, if you want to know more about the Trust Administration class, you can go to In God We Trust Academy on YouTube. You can follow us there, In God We Trust Academy on YouTube, and you can just go and look at the past few last videos that I've done. Just going to explain to you a little bit about this, but the time will be at 10 a.m. Central Time. You can do this in live stream or in person. So we'll be at 99 Elgin Parkway, Suite 14, Fort Walton Beach, Florida, which is near the Destin area. So if you're in Destin that week or want to come or just enjoy a good time, you're in Florida, the lower parts of Alabama, Georgia, or just want to fly out and come enjoy with us, guys. July the 26th. We're going to teach you literally how to administrate your trust. As we know, people get trust all the time but have no idea how to administrate it. They just know, hey, I'm a trustee. But there are duties and things that the trustee is supposed to do in order to create wealth, not only just creating wealth, but to literally be able to protect the trust assets, whether through arbitration, through court, or anything of that nature. And just learning how to set off in certain things with companies and stuff like that when it comes to bills or using trust property, right? Learn to leverage the trust is what you need to learn how to do. So again, if you want to be a participant of this, go to ingodwetrustacademy.com. Again, that's www.ingodwetrustacademy.com, and you will be able to sign up there. If you want to know a little bit more about it, as I said, you can go to our YouTube channel, In God We Trust Academy, and you will be able to learn more about what this class is going to be offering you. Or just wait till later on the day. You'll hear me talk about it a little bit more. And then right after that, August the 9th, we're going to be in the Houston area, around Missouri City as well. And we're going to be talking about the hidden ledger, basically fractional reserve banking, teaching you guys how to gain your equity because they lease every year put like $1, 25, maybe 15 cents, 30 cents. I don't know. Just depends on what you had in your bank account for them to be able to use it. But just know if you put $100 in there, then they can make 1,000 out of that 100. And $900 in equity is literally supposed to be able to be going to you in a certain manner, at least a percentage of that. If you know how to leverage that in a non-interest bearing account using a trust, then that is definitely something that you can do. If there's something that you also want to learn, be able to participate on this. And again, this is August the 9th. You can go to ingodwetrustacademy.com. And if you want to learn a little bit more about that, you can also go to our YouTube channel, In God We Trust Academy, to learn more. All right. And we also have for you guys today. So today we're going to be talking about this due process defense workbook here. And if you happen to get this, if you want this workbook for free, all you got to do is purchase 2 MNRP raffle giveaway tickets. And that's what will be coming with it. So if you get the workbook, you will be getting 2 tickets. So we're going to go through the workbook today with you guys. And what is the raffle giveaway for? We're going to be giving away a 2026 Toyota Camry in February, right? February 2026, we're going to be giving away a car, a brand new car, 0 miles, and a few $100 cash prizes. And you can, how to enter is a $10 donation per ticket. You can buy as many tickets as you like. You must have a ticket to claim any prize. But today, the only thing you're going to have to do is purchase this defense workbook, and you will receive 2 tickets, which will give you a chance at winning this particular Toyota Camry, right? So if this is something that you're interested in, stick around with us for us today, and we're just going to go over a few things. We also have right now going on in GodWeTrustAcademy.teachable.com is our debt liberation class. So if you're interested in that, you can literally go to our debt liberation class, and it's going to teach you how to beat collectors, discharge mortgages, and literally just redeeming lawful money. And this is a powerful course that teaches you how to beat third-party debt collectors, lawfully discharge debt without using money, and exit contracts through breach. You'll learn how to set off obligations, redeem debt using lawful methods, and expose how banks act as debtors, not creditors. Discover how mortgages are prepaid through your promissory note and how to discharge them fully. This is not about a theory, family. It's all about legal remedies rooted in contract law, equity, and commercial truth. If you're ready to cancel debt, protect your rights, and walk in power, then, guys, this is the course for you. It has 12 lessons, okay? Anywhere from about 2 hours long for each one. So you can get on there and literally go at it. It's $350 if you want to, but they also have a flexible payment option available as well. It's at checkout, so it'll give you at least $32 a month if that's something that you want to do based upon a payment plan. You're more than welcome to do so. All right. Other than that, though, man, how you guys doing out there? Drop some ones. If you're with me, let me know how y'all doing. Is you with family? If you're with family and able to take your time out with me right now, very much appreciate it. But today, we about to jump into this session with you guys, right? We're about to jump in this session with you guys. So this is the In God We Trust Academy defense workbook here. And we're just going to be showing you guys a few things that's we're going to be going over today. All right. And just to let you guys know where we're going to be coming from. And this is going to be important because, again, a lot of you guys today, you are going to get tickets. Some of you guys going to get pulled over. Somebody's going to jail. Yeah, that's going to happen today for sure. That's just what this day brings. You're going to go through a roadblock. You know, some of y'all ain't all the way together. So, you know, you're going to be going through a hassle. It will happen. It will happen to you or somebody that you know today. That is a fact. It happens every year, right? So, you know, they got these roadblocks set up waiting for you today. So I guess it's best to just talk about your rights and certain things to look for with these traffic citations today. So I'm gonna help you guys out today. The only thing I ask you to do is like, share, and subscribe. Share it with somebody to help inform them of their full rights today. Okay? So, In God We Trust Academy presents to you guys a due process defense workbook. Okay? Yeah, it is a workbook. Let me let you guys see what that look like, what you'll be getting. It's a full workbook here. And has a few things in it and just basic things are not too long, maybe about 15 pages at the most, but just to give you a great idea of what you need to do, how to do things, and where do we go from there in doing these things, correct? All righty, man. Well, let's not hesitate. Okay, let's not hesitate on what we are going to do here. All right. So here's the thing. A few things that I want to talk to you guys about. Understanding your court procedures and what you're going to be going through. If you get a ticket today, if the city give you a ticket, if the county give you a ticket, if the state trooper give you a ticket, no matter who gives you a ticket, it is going to go into what I like to call inferior courts or municipal courts. And in these particular courts, they only have what you call bench trials. And these bench trials means these are trials without a jury. But here's the problem, though. These particular settings literally violate the due process of law. Okay? There is no jury setting here for you. And according to the Sixth Amendment, it tells you that all criminal prosecutions, okay, all criminal prosecution has to be done with a speedy and a public trial by jury. It's very important that you understand that. All right. Now, I know that you guys are getting these courts, and the first thing they'll holler and tell you is, hey, I don't, how they'll say it, that they basically don't have they don't hear constitutional things in the court. It's not about whether they hear it or not, because they don't have the jurisdiction, but it's how you use it to challenge the jurisdiction of the court. Okay? Now, I know a lot of you like, oh, they'll ignore it. No, ignoring is one thing. Denying is another. Ignoring means it's if they act like they didn't see you filed a motion and they don't give a hearing and the judge does not make a decision on it. Denying it is just the judge denying your motion, et cetera, whatever the case may be. Okay? Now, the only thing that we want to make sure that we do in this particular setting is we want to preserve the record, because that Article 3 court that everybody's looking and searching for is the highest appellate court. All right. And that's the appellate court before you get to the actual, it's the appellate court before you get to the actual Supreme Court. I'm not talking about from a municipal court to a superior court, because even in that superior court, they're going to still try to run a bench trial. You see what I'm saying? They're only going to hear according to the statutory evidence of codes, et cetera, unless still challenge your right. But even then, if it makes it there, you still will have a chance. But on main thing we want to make sure we do is always preserve the record. All right. Now, here's my thing. Y'all celebrating today. And I really think that if you're going to celebrate this in any type of way today, do you understand? And let's just look at it from, everything in a perfect world of the United States. We're going to look at it in a perfect world as if certain things didn't happen, but we're just going to look at it this way. So these particular people decided to, number one, separate themselves from Great Britain and declared themselves as an independent state and was literally ready to go to war for this particular situation. And the independence of this was literally knowing that each individual who took part in this was in the admission of asserting their right and understanding their right and knowing their right, operating within the Constitution and being able to assert it at all times. See, the independence came within the people. And that is the same thing that needs to happen today. You need to independently know the law yourself, right? It's not to depend on any form of lawyer or attorney or a public defender or anything of that nature. You have to know the absolute law yourself because they are not there to help you. They are there to turn you over, okay, to the jurisdiction as a ward of the state to the court, right? And they're only going to treat it in that manner when they only start operating according to statutory provisions for you. Has nothing to do with fully protecting your rights and your inalienable rights as the people. So if you find yourself celebrating today, because it is the Independence Day, the 4th of July, and a lot of people just celebrating because you just get with family. It's you off work, you can get with family. But however, you need to be able to know these things because today they waiting on y'all, right? As I said, somebody's going to jail today. Police going to be called to a lot of different places. Fireworks is going off. Tickets going to be given out. Roadblocks going to be set up. It's going to it's happening right now, right? All right. So it's been happening since, they actually started a little early. So when it comes to getting into these courts, what is the first thing that we should do? Okay. Affidavit of facts, right? You have an affidavit. They're going to bring you into an arraignment first and foremost, and it's going to say, hey, are you guilty or not guilty or nolo contender? Do you choose not to contest, right? And a lot of you guys will be like, hey, I don't submit myself to the court and I don't do this and I don't do that, but blah, 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 yah, right? Yeah, just that, none of that matters, okay? It really doesn't. Because even if you consider yourself to say, hey, I'm not guilty, it does not place you in a jurisdiction still. Because if you're not guilty based upon violation of due process of law, there is no jurisdiction for them to have in the first place. And that is your absolute right to assert, to say, hey, according to the law, et cetera, and the violation of due process of law, I'm not guilty. And there is no subject matter here for the court today, right? And if that's the case, then the case should be dismissed, right? Which is why behind the affidavits, you fully explain certain things. And an affidavit is your sworn firsthand testimony setting the factual and legal foundation of your defense. And your affidavit is your evidence. Okay? It documents your private, non-commercial use of your vehicle, your constitutional right, especially the 6th, 9th, 10th Amendments, and your objection to unlawful procedures. The 6th protects the right of the jury trial. When we start getting into the 9th and the 10th, we're talking about enumerated rights. And then we're talking about the rights that are only left with the people, right? So, with that being said, it's to the people to assert their rights. So by filing it first, you're going to preserve your position on the record before the court tries to move forward. And what does it do? It creates a formal and sworn account that the judge, prosecutor, and the appellate court must consider. And that means that from the very beginning, you have to assert your right. You can't leave out anything, guys. You can't leave it out. Because if you leave out anything, you cannot present any new evidence when it comes time to appeal. Okay? We can't do it. Okay, so this established that you were not engaged. We can say that you wasn't engaged in commercial activity. So license laws regulating commerce shouldn't apply to you, and it affirms your constitutional right to a jury trial and due process, providing a clear basis for every subsequent motion or defense strategy. That is what we want to place in our affidavit. Okay, we want to have that in our affidavit. Drop some ones if you're with me, family. I need to know that you understand, because a lot of you guys think just let's file an affidavit. All right. And in just filing this affidavit, you think that that's all you need is just to file the affidavit. And that's not true. You need more than that, because an affidavit is just the facts. Okay? That's it. All right, so now behind every affidavit that you're going to file, if you file an affidavit based upon whatever reasons, then the next thing that comes behind that literally affidavit should be a motion to dismiss. Now, why should you do it? Because you're directly asking the court for the ultimate remedy you're seeking, which is dismissal of charges based on lack of jurisdiction, failure to provide due process, or violation of constitutional rights, particularly the Sixth Amendment, to guarantee a jury trial. As I told you, every bench trial court that literally deals with any form of liberty we can get rid of. Okay? It forces the court to decide whether it can lawfully proceed the given constitutional and jurisdictional defects you raise, and it shifts the burden onto the court in prosecution to prove they have a lawful authority to prosecute you. Okay? And it also shows the court that you are asserting your rights firmly but lawfully, which may prompt the prosecutor to reconsider moving forward or negotiate, right? That's the next thing. So now, once we have that set up, we're on the way, okay? Now, they got one or two options here. We filed the affidavit here as the facts of our evidence, and according to our evidence, we are going to file a motion to dismiss, and we're basing it off the evidence that we have within the affidavit, right? They need to dismiss this. So they got one or two things to do here. The judge can either grant it, well, we're going to say three. The judge can grant it, deny it, or just completely ignore it. If they grant it, great. Case dismissed, walk on up out of there. If they deny it, that's fine. Not going to worry about it. Now, if they ignore it, it's also a violation of due process. So if they ignore it without giving you any form of hearing, without denying or granting, etc., then we still have preserved the record and to make sure. But you have to understand that if they come back and they try to have a trial date, you need to fully learn to, well, do an objection. You need to learn to object the court because they cannot continue to a trial until they have a hearing on the actual particular motions. You want to do that literally to preserve the record. All right. Now, let's say they deny it. If they deny it, well, it's time for discovery. It's time for the discovery. And this is where it all gets so fun at because they ain't going to be able to produce a damn thing because they already in the wrong. Right? But we're going to play the game anyway, though. Play the game like a sport. You feel me? Got to play it. So let's play the game. Well, now we're going to do a motion for production of evidence. And why do we do this? Because it demands proof behind the prosecution case and the court's claim authority, including the verified complaints of harm, the officer's lawful oath and bond, evidence you were engaged in regulated commercial activity, and the court's statutory authority to deny a jury trial. We want to see it all. Thank you for the gift. We want to see it all. We want to see it all. It invokes your due process right to confront evidence used against you. Okay? So that means it forces the prosecution to show its hand. If they fail to produce required evidence or authority, you can move to dismiss for lack of jurisdiction or prosecutorial misconduct. And that's literally meaning, hey, this case needs to be dismissed for lack of proof, they can't prosecute for lack of evidence. Failure to prosecute for lack of evidence. Let me choose to say it like that. And this is going to strengthen your defense by exposing gaps or procedural errors. So we want to preserve grounds for an appeal by creating a detailed record of your request and the government's response or failure to respond. Now, if you pay attention now, I didn't just say like, hey, go in there and challenge jurisdiction. That's not how we're doing it. But if you heard what I said, according to the procedures of what I said do, we challenged the jurisdiction. We're already challenging it. Without saying, hey, I'm here just to challenge jurisdiction. Like, no, we're literally following the rules and procedures of the courts, using the letter of law, and being able to challenge the jurisdiction by literally stating in our affidavit these few things that I'm going to present to you and doing a motion to dismiss. And also, if they deny whatever the case may be with that, we're going to do a motion of production because we want you to provide your full evidence here that you have to do this. So what this is going to do is this is going to build a strong, lawful record asserting your constitutional rights. It make it much harder for the court to railroad you through a bench trial without respecting your due process rights. And it forces the court and prosecutor to operate under the law, not just local custom or policy. So we're going to set up the stage for an appeal if your rights are ignored. So the main thing I want everybody to wrap their mind around is always think about the appeal. We want to make sure that we preserve the record at all times for the appellate court, because the appellate court only deals with law and fact. Okay? The law and fact, meaning the due process of law and the facts that are presented within the actual case. Now, once you do that and we preserve the record, then we know we have a win. That's the reason why it asks us in the Bible to be perseverance, right? Be perseverant. Stick to the law, follow the word, fulfill the law. If we fulfill it, we persevere, we surely will receive a remedy that we are seeking, right? That's what we want. That's where we want to be, man. Drop some ones if you're with me. Drop some ones. Let me know you alive out there. We're about to go over this affidavit with you guys. So let's go over this affidavit. All right. Okay. In this affidavit here, you guys got to understand one thing here. This is the affidavit of the workbook. Just letting you guys see what's in this workbook. This is what I'm about to read and go over with you. Okay? So I'm going to give y'all a little glimpse. Let you know this is the affidavit of the workbook. Now, if you're in Alabama, you can definitely use this. It also applies to other states as well. You just got to find the different codes that relates to your state or within your constitution and things of that nature, right? But in the affidavit, we need to be very clear about a few things, okay? One, we are the living man or woman competent to testify, being duly sworn, state the following facts of firsthand knowledge. I am the sole owner of the private conveyance described in the citation issued on or about whatever date, which is my private property used solely for personal and non-commercial purposes. On the date of the alleged offense, I was traveling in whatever city on the land solely for personal, non-commercial reasons, exercising my inherent unalienable right to travel freely upon the land, the right-of-way with my private property. I was not engaged in transportation of goods or passengers for hire, nor operating in commerce as defined in Alabama Code subsection 32-1-1.1 or any other related statutes or administrative codes. You can find this, right? The alleged charges are classified as criminal offenses. Listen, they're classified as criminal offenses. All right. Now, according to the state and or city, carrying potential penalties of fines and or incarceration. So this means that this deals with liberties. Liberties, right? Okay. This is what this is dealing with. And it means that you could lose a form of a right due to this actual situation. So since these liberties are involved, there has to be a jury trial here. We can't just do a bench trial. So this is making this matter a criminal prosecution under the Sixth Amendment. The Sixth Amendment guarantees, and this is what it says, in all criminal prosecutions, not some, but all, every single one, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Okay? Article 1, subsection 6 of Alabama Constitution also confirms that in all criminal prosecutions, the accused has a right to a speedy and public trial by an impartial jury. They both say the same exact thing. So that's what we're going to assert because we're just stating the facts. And our facts is considered to be evidence here. All right. So the U.S. Supreme Court in Duncan versus Louisiana, 1968, held the Sixth Amendment's jury trial guarantee applies to the states through the 14th Amendment due process clause. So we're going to exercise the 14th Amendment, which literally makes sure that the state has to provide the same due process clause, meaning all criminal prosecutions as well. So you can exercise that and or the one of your state. Both. It's what I'm telling you. Okay? So now the 5th and the 14th Amendment guarantees that no person shall be deprived of life, liberty, or property without due process of law, which requires a valid court of competent jurisdiction and an impartial tribunal. But there's a bench trial, though. Can they give this to us? I don't see any jury that's been picked. And then you got to understand it costs money to do jury trials because they got to pay every individual on the jury. They got to pay their time to operate within the public system. They must be fully compensated because, hey, there's no involuntary servitude here. Nobody's working for free. We're not slaves out here. You're going to pay somebody. This is why they run away from jury trials, because they got to pay. And if everybody just literally took stuff to trial like they're supposed to, trust me, there would be so many things that they wouldn't even try. They would literally dismiss it because they knew they didn't have the amount of evidence to prosecute you in the first place, right? And the 9th Amendment to the Constitution states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And the 10th Amendment declares the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So the 9th and 10th Amendments confirm that the people's inherent rights pre-exist and take precedence over the Constitution and any statutory administrative regulations. These amendments enshrine the principle that the government exists to protect pre-existing rights, not to grant or restrict them. So you got to understand the right to travel was always a pre-existing right before the Constitution, no matter how you travel within your own private property. So the right to travel freely with one's private property without permission or a license from the state is a retained right of the people secured by the 9th and 10th Amendments and rooted in common law and natural law predating the Constitution. Always have been, always will. No statute, ordinance, or administrative rule can lawfully convert the exercise of a right into a privilege or subject it to a license or fees. Requiring a license to exercise a right violates fundamental due process, as recognized in Murdoch versus Pennsylvania, 1943. Got him. Right? And all this is just in our affidavit, guys. We ain't even went nowhere. We just stated. See, a lot of y'all think the affidavit has to be about you stating facts about the situation that happens. No, we're going to talk about the law itself. Let's put that in our affidavit because this is our evidence. This is our facts. And each one of these things have to be rebutted. They can't rebut what is already known and seen, right? Can't do it. So I have seen no lawful authority granting this municipal court power to deny a jury trial or conduct a bench trial in a criminal prosecution, as the Sixth Amendment mandates a trial by jury in all criminal prosecution, as well as the state constitution says the same thing as we read, right? Think about this, man. See, and people just walk in there and say so much different stuff when just stick to the facts and the law here. We don't have, matter of fact, we don't have to claim all this other stuff for real. Just stick to the law and make them, because they took an oath to it. They took an oath to defend and protect this. So let's just put it in their face and let's see what you do. Let's see if you're going to really do what you're binded to do, right? Let's see. Proceeding without a jury trial or without proof of the court's lawful authority causes irreparable harm to my fundamental liberties, denies due process, and renders any judgment void for want of jurisdiction. We got them. And I'm saying this because y'all finna be out there drinking, Well, God knows what else you're going to be doing. You're going to get on that road. They're going to give you a ticket. Somebody going to jail. You're going through a roadblock. You ain't got your registration or whatever all together. And if you know this, it'll save you some time and money. It'll save you some time and money. And I know the state they say the United States is in today, y'all got a lot of time, but there ain't a lot of money floating around, right? So hold your coins in your pockets, man. Don't get them knocked out of you like Sonic now. You don't want to get the coins knocked out of you. Let's make sure we good. So now we're going to reserve all rights secured by the Constitution of the United States of America, the state constitution. In this case, we're saying the Alabama Constitution, common law and natural law, including but not limited to rights protected by the 5th, the 6th, the 9th, the 10th Amendment, and Uniform Commercial Code 1-308 within the state. Make sure you mention the state because the state has literally adopted the UCC, not the federal government, just the states, without prejudice and without recourse. All right. So now what makes it an affidavit is the fact that you go under penalty and perjury. If you're not under penalty and perjury, it's not an affidavit. Let's make that clear. So now that we got the affidavit, right? Now we're going to do a motion to dismiss for lack of jurisdiction. This is the challenging of the jurisdiction. So we already stated all of the facts, right? Now we're going to deal with the lack of jurisdiction, and they need to dismiss it for violation of constitutional rights if they continue this proceeding. So we already put all the facts there. We got all the evidence because we used the law. All right. The law is evidence within itself. That's the reason why you can put in judicial notices, and all judicial notices are considered evidence. And judicial notices is just literally law and case laws. That's it. That's presented as evidence. So we got that down pat, right? So now, motion to dismiss comes now. The defendant appearing in appropriate persona and respectfully move this honorable court to dismiss the charges against the defendant for lack of jurisdiction and violation of fundamental constitutional rights, and as the grounds states the following. So we're going to start with the 6th Amendment, guarantee of jury trial. The 6th Amendment to the United States Constitution provides, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. So the charges against the defendant have been classified as criminal offenses, carrying potential penalties, including fines and or incarceration, making this a criminal prosecution within the meaning of the 6th Amendment. Now, also within the Alabama Constitution, Article 1, Section 6, similarly guarantees the same thing, that all criminal prosecutions, the accused has the right to a speedy public trial by an impartial jury, etc. Right? So now, we got them by the state constitution. We got them by the United States of America Constitution. We got them by both. So now what has to happen is every statutory provision that they're going to use has to be in harmony with what we just said. If it is not, it becomes a conflict of interest here. And the situation is that the constitutions will always prevail over statutory law when there is a conflict, right? Every time. So denial of jury trial violates due process. As we said in Duncan versus Louisiana, the U.S. Supreme Court held the right to a jury trial in criminal cases applies to the states through the 14th Amendment's due process clause, and proceeding to a bench trial in a criminal matter without affording the defendant a jury trial violates the 6th Amendment, the Alabama Constitution, and due process rights secured by the 5th and the 14th Amendment. We got them. So now what we just did, guys, we just took jurisdiction away from them. This is challenging it because we're using the law showing how they don't already have it. So that's why I say saying not guilty because of violation of due process, we're saying that there is no jurisdiction for you to have here in the first place. So if we challenge that through this motion and within our affidavit, they have to place it on the record to prove it. The burden has shifted to them. We've already expressed ourselves using our evidence, which is the law, right? Our evidence is the law itself. So now they have to figure out what they gonna do. What they gonna do. We ain't done yet. Lack of lawful authority to deny jury trial. They don't even have the authority to deny it. Defendant has seen no law, statute, ordinance, or constitutional provisions authorizing this municipal court to conduct a bench trial, okay, in a criminal prosecution or to deny the Sixth Amendment guarantee of a jury trial. The absence of such authority deprives this court of jurisdiction to proceed, right? That's what we want to know. It's not there. We haven't seen the statute. We haven't seen the law that gives you the power to take away our right, our due process. Have we seen it? It's the question. And the truth is, it don't exist. Now we're going to go to the 9th and 10th Amendment, the pre-existing rights, which to the U.S. Constitution affirm the rights retained by the people pre-exist and take precedence over statutory or administrative regulations. The right to travel freely within one's private property is a retained, unalienable right, not subject to conversion into a privilege by licensing scheme. Right? Violation of due process and requirement of impartial tribunal. Due process of law demands that before depriving any person of liberty or property, as I said, when it comes to your liberty and property, there got to be a trial here. The government must establish jurisdiction, prove lawful authority, and provide a neutral, impartial tribunal free from conflict of interest or revenue incentives. Proceeding without meeting these standards renders any judgment void. So we got what I always tell y'all: the truth is the affidavit of facts. The proof is a law. Okay, truth, proof, which is our evidence. All right, in the law. And then we got the actual law itself, which is what we're speaking on. And then now it's time for our relief. So truth, proof, law, and relief is what we want to do. Truth, proof, law, and relief. So now it's time for the relief. Wherefore the defendant respectfully moves this honorable court, dismiss the charge with prejudice for the lack of jurisdiction in violation of the defendant's constitutional rights under the 5th, 6th, 9th, and 10th Amendments to the U.S. Constitution and Article 1, subsection 6 of the Alabama Constitution, preserve all objections for appellate review. So we're preserving all objections for the appellate review and grant any other relief this court deems just and proper here today. All right? That's what we want. So now we got our affidavit. We did our motion to dismiss, to challenge. Now, after we put this in, we just sit back and wait. Only three things that can happen. Grant it, they deny it, or they just completely ignore it. If they grant it, we win, we out the door. If they deny it, we got something else to do. If they ignore it, we still got something else to do. Because that means they can't proceed any further. All right? Any further. They can't proceed any further without hearing or making a move on the actual motion that we have just done to dismiss the court. Right? We have to stick them to that. So if they do move forward and go straight into a bench trial, guess what? We automatically win. It's a violation of due process of law. We just need to make sure that we place that and also put that into the record, on the record, and also within the trial to let them know that they have fully violated the proceedings, and everything that they do within this moment and forward is considered void. It's not voidable. It's already void, as we have already determined. So let's say that they denied the dismissal. So now they got to prove it. Oh, okay, you're going to deny. So you denying what we saying? If you're going to deny what we saying, then you got to prove it. Prove that we're wrong. So now we're going to do a motion for production of evidence of jurisdiction, authority, and due process. So we're going to appear in the appropriate persona, respectfully move this honorable court pursuant to the 5th, the 6th, the 9th, and the 10th Amendments to the U.S. Constitution, Article 1, Section 6 of the Alabama Constitution, and applicable rules of criminal procedure, and controlling legal principles requiring proof of jurisdiction to compel the production of the following evidence and documentation. Number one being produce verified evidence that the defendant is a U.S. citizen as defined by federal law, or that the defendant knowingly, voluntarily, and intentionally consented to federal statutory jurisdiction. Got to prove that. We want them to produce the evidence that the defendant resides or is domiciled in a federal area as defined in 4 U.S.C. Subsection 110D and the Buck Act provisions conferring jurisdiction upon this municipal court. Got to prove that. Now we need them to produce any valid contract signed by the defendant in which the defendant knowingly waived unalienable rights or consented, to statutory jurisdiction. Got to prove that. They also got to show what? Proof of lawful authority for this court's action. Yeah, we need to see it. So now we need them to produce the statute, the ordinance, executive order, or delegation of authority granting this municipal court power to deny a jury trial in a criminal prosecution or to conduct a bench trial contrary to the Sixth Amendment guarantee of a jury trial in all criminal prosecutions, and or Article 1, subsection 6 of the Alabama Constitution. They got to prove it. So what power, what happened? Was there something amended? Did something grant them authority? And a statute cannot grant you authority over a constitutional law. An ordinance cannot grant you authority over constitutional law. And even an executive order cannot grant you authority over a constitutional law. There's nothing they can show or prove that's going to show that they can grant authority over constitutional law. The only thing that could happen is something was amended, and there was no amendment. So show us the amendment. Can't do it. Now, again, I'm telling y'all this today because it's Independence Day. Y'all at the grocery stores, you got all this stuff you about to grill. You got about 3-4 cases of beers, some Don Julio, and all this good stuff. You're going to be traveling on the highway. You're going to get pulled over. You're going to get tickets. Some of you going to jail. Some of this, some of that, a little bit of everything going to happen. So you need to know your rights because they're definitely going to take you straight to a bench trial. Since we're celebrating Independence Day, know your rights. How can you celebrate something in the meaning of what it was supposed to mean and you have no idea about the rights that you carry? So we want them to produce documentary evidence that this court and its officers act as a neutral, impartial tribunal free of conflict of interest or revenue incentives as required by due process. So that means anybody making money off this case, you got to go. Not one single person in here can. We need that proof. We need to produce the official oath in office, bonding documents, and delegation of authority for any presiding judge, clerk, magistrate, or other officer involved in this matter. Because we want to make sure that you're lawfully holding office right now before you make any moves or judgments in here today. We have to see it. Because we already did a motion to dismiss based upon the reasons why you should, according to the Constitution. And since you can't provide those things or you're going to continue to move forward, then now we got to make sure that you are who you say you are. So I need you to produce this for us today on the record. We have to. Now, we also need proof of lawful authority of the citing officer. Was the officer lawfully holding office? That's another question. We get to ask because sometimes they don't have a bond. Sometimes they're not doing everything correctly by the city charter or whatever the case may be and not correctly holding their office, which will literally make anything and all things that they did was void in the first place. So we want them to produce the lawful executed oath of office of the citing of the arrested officer as required by the Alabama Constitution and applicable Alabama law, and produce proofs of an active and valid bond for the citing of the arrested officer as required by law to ensure faithful performance of official duties and accountability to the public. We also want them to produce any delegation of authority or training documentations demonstrating the officer was lawfully empowered to enforce statutes against the defendant at the time of the citation or detainment. Hey, we just want to know that you were lawfully holding your position. We need to see that. You can't be out here faking like a cop, don't have everything. Just because you got the badge on and don't have everything that's necessarily supposed to be done. Because a lot of them let their bonds run out, don't have a bond at all kind of different stuff. Haven't fully followed through with what they were supposed to do. happens more than you guys think. We need to see that. Now, the next move is evidence of factual basis for the alleged criminal charge. So we need to produce a sworn verified complaint from the injured party attesting to actual harm or injury caused by the defendant alleged conduct. Produce any evidence demonstrating that the defendant was engaged in transportation or commercial activity subject to Alabama motor vehicle regulations or your state, distinguishing between private non-commercial travel protected as a right and regulated commercial conduct. And if the charges involve alleged speeding violations or measurement devices, produce the calibration, the certification, and the maintenance records for the radar, the LiDAR, or other speed detection equipment used during the incident. We need to know that you calibrated it that day. And I guarantee you they don't. They just walk by, pick it up, and keep it going. They don't. Man, y'all know people, man. Y'all think people do? No, they don't. People are lazy. People will always be lazy. People will always cut corners. And that's why I say due process of law is so precious that there can't be one single error in it at all. If we find one single error, the case has to go. Has to. So you got to think about the first responders. The first responders are literally the lowest IQ in law. And they come out there on ego. Majority of them step out on ego. You see what I'm saying? And if they step out there on ego, they ain't not paying attention to any form of due process here. None whatsoever. So the United States Supreme Court has consistently held jurisdiction is never to be presumed. It must be affirmatively shown on the record. United States versus Minker, 1956. Okay. Due process under the 5th and 14th Amendments requires proof of jurisdiction and authority to any deprivation of life, liberty, or property, and mandates proceeding before a neutral and impartial tribunal. We need to see that. We need to see that. Okay. Now remember, truth, proof, law, and relief. Now we need the relief. Wherefore, defendant respectfully prays to the honorable court to move the honorable court. Order the prosecution and or court officer to produce the requested documents, records, and proof of lawful authority prior to any further proceedings. Okay. Acknowledge that the failure to produce the requested evidence constitutes a fatal jurisdictional defect requiring dismissal, and preserve all objections for the appellate review and grant any further relief this court deems just and proper. Right? I mean, we just want to know, is it any help out here for the widow's child? That's all. That's all. That's all we want to know. Start putting that on your documents and see what they do. It is a sign of distress call. All right. So right now we did the affidavit. We did the motion to dismiss. If they deny that, we go straight into the motion of production for them to show proof of everything. All right. If they don't show proof, do motion to compel. All right. You also still have motions for admissions, which means that if they don't show proof of any of this, you do a motion for admissions to say, hey, you admit everything that we just said, right? You can go point for point. All right. You also got your motions for interrogatory, so you can ask questions to whoever. You also got your motions of your deposition to do as well. So we can literally call out people and record, have a recording for their testimony or whatever the case may be. We also got there's a few other things that I could say. You got motion to strike. You can motion to suppress any form of evidence. You can do a lot of different things. Okay? A lot of different things here. So, step 1, prepare your documents. Affidavit of facts, motion to dismiss, and motion for production of evidence. Those 3 documents can already be put together. You do not have to wait for a motion for production of evidence. Okay? You want to include your full name. case number, court name, current date, or on each document. Want to make sure that we make at least 2 copies. Make sure that we attach a certificate of service, or you could just put certificate of service on the bottom of your document. It'll literally say certificate of service. I certify that a true correct copy of this document was served upon the office of the city prosecutor, etc. Right? That's it. That's all you got to do. You can put the mail number if you want to, however you choose. Then we're going to make sure that we file it with the clerk, the court clerk. So you can either go to the clerk's office at the municipal court listed on your citation, hand the clerk your original signed documents for each motion and affidavit, ask the clerk to file stamp your copy so you know they have proof they were officially filed. Or again, if you send it in the mail, the day you put it in the mail, it's already considered to be filed into the court. All right. And anytime that you give the actual clerk any form of documentations, it's considered filed then. As soon as you put it in their hand, it's filed. Whether they want to stamp it or not, it's filed. Okay? Keep your stamped copies in your records. You need them if the court or prosecutor claims you didn't file. Keep it. Make sure you serve the prosecutor. You can mail it or hand deliver it, however you may choose. Preferably certified mail with return receipt if you mail it, and this gives you proof of service. You want to keep proof of the filing service at all times. Bring extra copies to the court. Okay? On the court date, bring you some extra copies. If the judge or prosecutor claims they have not seen your motions, you can hand the copies to them immediately. Be ready. Be prepared. Here you go. Give them out. All right? Prepare to assert your rights in person. Know what you're talking about. Okay? Your Honor, I have filed affidavit of facts, a motion to dismiss, and not yet, but you can say a motion for production of evidence, and I assert my right to a jury trial under the 6th Amendment and preserve all rights. If the judge ignores your motion, respectfully object, request a ruling on each motion. Okay? We want a ruling. That's part of due process. And now what they're hearing is that you understand procedures and they know not to play with you because they understand that you're preserving the record. Remember, this Independence Day. Everyone should know their rights since we're going to be celebrating today. Y'all going to be shooting all these fireworks and stuff, and you ain't going to sit down with your children who you letting go out here into this world and just not knowing their rights in any situation. They finna get tickets and be ready to go to court with nothing. Hey, how do you plead? Guilty or not guilty? And they go ahead and pay, not knowing that they in a whole bench trial proceeding that does not offer the jury trial that they seek and demand for. And even if they was to say not guilty and take it to trial, they still don't know that they still operating in the bench trial, and it's a criminal procedure, and they are afforded a impartial tribunal. Right? Think about that. The lack of our people today, and everybody about to be drunk, lifted today, as y'all would say. Come on. Right? Let's get it together. Preserve the record for the appeal. That is the main thing. It does not matter if they deny or anything like that, because that Article 3 court you're talking about is the highest appellate court that we're talking about. Not the Superior Court, but we're talking about the appellate court before you get to the Supreme Court. That court right there is going to look at law and facts. When I say law, due process of law. Yes, request a ruling for each motion. Right? So make sure if the court denies your motions or proceeds with a bench trial, right? And we say, I object to the proceeding without a jury trial and I preserve all rights under the Constitution and applicable law. Make sure your objections are spoken on the record or included in written filings. Now, these actual municipal courts don't have a court recorder. So what you need to make sure that you do is put your objections in writing and make sure you file them. It's on the record. Okay? Now it's on the record. If they denied your appeal, it's because you put in your appeal wrong. And you got to make sure that appeal is done absolutely right. It has to be done in accordance to the rule of law and how they tell you they want to receive their appeal. If there's anything or slightly wrong done in it, they definitely will deny your appeal. So make sure that you know how to do that. That's the reason why I had a master in appeal class, to teach people to know how to actually do an appeal. Okay? Now, this process creates a clear, documented trail showing you asserted your rights, demanded due process, and made every good faith effort to resolve the matter lawfully, which is essential if you need an unconstitutional ruling, my good people. All right. So, everything that I just read to you, everything that I just read to you and spoke to you about, you can go right now to InGodWeTrustAcademy.com, right? And you can purchase this ebook. Well, it's a workbook, right? Has everything that I just said within it. InGodWeTrustAcademy.com. It's only $20. $20. And what that $20 is going to do, it's also going to give you 2 of these tickets. So that $20 is going to give you 2 tickets for our MNRP raffle giveaway of a 2026 Toyota Camry car, brand spanking new. We're going to be giving it away February 21st, 2026. So this is your chance to receive these tickets and win, and also have a great little small ebook here, workbook that you can actually do to assert your rights. Okay? So yes, it's there for you guys. It has a step-by-step process. It literally has the motions and templates in here for you. Okay? There's the motion to dismiss. The other one was the motion to a production of evidence. And here is the affidavit. And just explaining to you why you should do these things the way that you want to do. $20 right now today. Right? And it's going to put you in a chance to win the raffle tickets to win a car. So you get 2 tickets. 2 tickets to win this car. Now, I hope somebody win it, because y'all don't win it, I'm going to be driving a new car. Nah, I got enough cars right now. But literally, 2026 Toyota Camry. And also, there will be a chance for you to win cash prizes of $500. So maybe you might win the $500. Who knows? But everything that I just told you is lawfully. It's not a theory. It's not all this stuff that everybody tells you to go in there. Hey, I'm the agent for the name. Yeah, I'm the agent here for the name. And then guess what? They'll start playing. Where we send the $20? Go to InGodWeTrustAcademy.com. All right, let me make sure you know that you know. In God, we trust Academy.com. And then you will search due process defense workbook, or just type in workbook, and it'll bring you here. And it'll show you this. You got a chance to do by PayPal. If you need more payment options, we also do Cash App as well. It's also on there. So if you read everything, make sure you read, guys. Read. I'm going to say this to everybody. Please read. Please do read. Okay? So we aren't the authorized representative to the all caps name. Yeah, you are the authorized representative to the all caps name. I'm not saying any of that. But none of that shit matters when you get in court. Only thing we're here to talk about is law and facts. So if I could present the law and facts, like that's why I say everybody looking like, well, where's the equity in court? Motions. Motions demands equity. It means do what ought to be done. So if I motion for production of evidence, then that means I'm looking for equitable performance. I want them to show me their proof. If I motion to dismiss for whatever reason, then this is inequity. I'm asking them to dismiss this case. That's why I'm telling you guys that law and equity runs parallel to one another. The court of law and equity, they run parallel in every setting. But you have to understand what equity is. And I don't think people know what equity is. But are you the authorized representative? Yes, you're all of that. That's absolutely right. But that shit don't matter when we get in court. We just here for law and equity. And all I need to do is hold them to the fire. You see what I'm saying? Because what they gonna start doing is they'll start playing games with y'all. You will start saying, they'll say, whatever, and then you'll be like, no, I'm here as such and such, the authorized representative. So they're gonna ask you again, is the name? Is John H. Doe here? And then you'll say, no, I'm the agent for the principal, whatever y'all say, right? So they're gonna ask your ass again. And then they're going to, after they ask you the third time, they're going to just be like, all right, we're just going to say that the John H. Doe is not here. Issue out a warrant for this individual. And then you will walk outside. And as soon as you walk outside, handcuffs will be placed upon you and your ass going to jail. You see what I'm saying? When y'all go in there acting like that, that's the situation. If you want to act and be a sovereign, the sovereign just knows how to exercise the law. You don't got to go in there and tell nobody. Like, do you got to walk in your house every day and say, hey, I'm the man of the house, or hey, I'm your mother, or I'm your father? No, you just be it. It's the same situation. You don't got to go announce that you are sovereign, you the people. They know that. You just need to know that. Because it's going to show by your actions. Are you going to act accordingly to how a person, an individual, the people are supposed to assert their right? Because by your actions, I can tell who you are. You can say anything out your mouth and get in here and start tripping. And when you start trying to do that type of stuff that everybody be trying to do, then what they call that is contempt of court, because you're trying to delay the court from its proceedings. You don't want to delay the court. Simple. If you ask, a lot of you guys go in there and say, hey, okay, I would just like to know the nature of the court. Is this a civil or criminal criminal nature? And they say criminal nature. Okay, well, if this is a criminal nature, according to the Sixth Amendment, that all criminal prosecutions has to be done by a speedy and a public trial by impartial tribunal, partial jury. Does this court has the power to provide that today? And then they're going to say no. And as soon as they say no, they don't have any jurisdiction because it's dealing with liberties. So right then and there, I just challenge jurisdiction without saying I challenge jurisdiction. You see what I'm saying? We can still take all the knowledge that we know about this situation and just move accordingly. You don't got to go in there saying all that old crazy stuff, because you're going to run into a judge just waiting to be an asshole to you. But when you walk in and the judge seen that you done filed an affidavit and a motion to dismiss based upon the fact that and you're challenging the jurisdiction to see if they have the power and authority to deny you a jury trial by an impartial jury. Yeah. Now we getting somewhere. And then if you ask them to produce their delegation of authority that's going to make them have to show, hey, show me where there was an amendment that, or some contract to where I waive my inalienable rights. I need to see those things. What gave you power to issue a bench trial over my right to a jury trial, since this is a criminal prosecution here today? Even the state constitution says that all criminal prosecutions has to be through a tribunal, impartial tribunal. Attack the capacity of the alleged at the time of the alleged act and omission. Facts. I like the way you worded that. That's real. That's what we got to do. And I'm telling y'all this. I did this specifically for you guys today. And like I said, it's $20 right now. It's only for the day. So if you don't get it today, it ain't going to be up there tomorrow. $20 for this particular due process defense workbook, everything that we just went over, according with the templates, etc. The rest of it is just for you to understand and find the laws within your state that's going to match up with what we're saying here and keep it moving. Because again, I said, somebody's getting a ticket today. Somebody's going to jail today. Somebody's going to get their car took today. It's going to happen. Somebody's going to go through a roadblock and get told, hey, pull over there. Yeah, I'm telling you. So you're going to have your kids out here in it. They don't care. They hopping in these cars. They're going any and everywhere. They finna party up today. It's a Friday, right? Holy Day is a Friday. Then you got coming up Saturday. So they got all weekend to boogie. And best believe they going to be out there all weekend too. You know what I mean? So you need to know the law. This is a very basic step in simple form to help you get out of these bench trial proceedings, right? And a chance to get 2 tickets. A chance to get 2 tickets to win a 2026 Toyota Camry on February the 21st, 2026. It's there for you. So go to In God We Trust Academy.com. Search workbook. $20. Ready for you guys today. All right. Go and get it. And that is the end of my presentation. Until later on tonight. All right. So if you want to watch this video again, you literally can, if you're on TikTok with us, go to YouTube and look up In God We Trust Academy, and this video will be there for you so you can continue to show your peers, etc. You say it ain't coming up. Let me show you how I do this. She said, it's not coming up. Okay, you see, I'm on the first page here. I'm going to hit that little search button over there in the right corner, and then I'm going to put work book. Oh, it didn't come up, did it? What happened? Let's go look up this. I don't know. Did they take it down from us? Let me go look, guys. Oh, you're right about that. Let's go get some straightening here. Let's make a phone call to see why it came down. Let me get my people in order here. Because they not going to like me having to call them and check them about why it ain't up. They're going to be like, I put this up there. It should be up there. Let's make this phone call. Hello? Yeah, I meant to call you because we looking it up on the website. It's not up there anymore. No, it's not. We just looked it up. I was on it, and then it went off. Well, what's the name of it? So you called it an ebook instead of a workbook. No, I did look up workbook first. No, it's not up there for real. I'm serious. Only thing I see up there when I put due process in is a few other things, but it's not what we just put. So you guys hold on. It's got to be up there. Give us a second. Oh, okay, it's up there now? All right, guys, go and check and see if it's up there now. Right now, go and check. Let me know if it's up there. Because I know she did not like me having to call. Yeah, there you go. Now it's up there. It did say workbook. Now she took it down. All right, it should be up there. Where do I get the book at? Go to In God We Trust Academy.com. $20 today. This will not be up there tomorrow, so do not come looking for this tomorrow, okay? This will literally be put with something else. But for today, okay? Yeah, you can just, you can type in ebook, but just put in due process defense, and it'll come up. Due process defense ebook. You can put that in the actual search engine. And if you want to know exactly where to go, as you just said, then I'll show you. See that? In God We Trust Academy.com. All right. You will get there. And then from that point, go over there, hit that search button. Look up due process. By the time you put in due, it's the second one right there. and it should pop you up right here. It's $20 in US dollars. You can use PayPal if you like. I think it also lets you pay by credit card if you want to, or you can cash out. Totally up to you. Make sure you read the instructions though. That's where everybody fail at. Read everything on there so you know exactly what to do, how to do, when to do, and why to do. All right. That's my gift to you guys today. So, and really the $20 is really purchasing the tickets. You're really getting the ebook free or vice versa. However you want to look at it. Doesn't really matter. But again, man, it's been great with you guys today. And I will see you guys tonight. And I'm pretty sure some of y'all gonna tell me, man, my cousin just got a ticket, man. You was right. You gonna let me like, yeah, we got pulled over. They tried us tonight. But I got you. I got you. Yes, I got y'all, man. All right, guys. Y'all have a great one, man. I will see you guys at about 9:30 Central Time tonight. Peace, love, and law. Again,